This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Ms. Higgs, Ms. Nelson, Mr. King, and Ms. Spengler. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Titch McGuire, Mr. Edson, and Mr. Edwards. And we are outside the presence of the jury. We have the final jury instructions and verdict forms, and I believe my staff emailed the parties both of those sets. Two things. First, I want to make a record that in terms of the model instruction on direct and circumstantial evidence, we were all in agreement in phase 2 that it should not be included in the jury instructions. I want to confirm that the parties continue to have that position with respect to the instructions here in phase 3. In other words, both parties believe that that instruction on direct and circumstantial evidence is not necessary and should not be included. Mr. Orman?
We don't believe it's necessary, and we are not requesting that it be included. If the defendant requests that it be included, we would not object to that.
All right. Ms. Nelson?
We're not requesting that it be included.
Okay, great. The second thing is with respect to the instruction that speaks about evidence that was admitted for a limited purpose, I indicated that I want to honor as much as possible the statute, and the statute is 16-8-107, subsection 1.5b. That subsection actually talks about the admissibility of the evidence, and it says that it can only be admitted for the limited purpose of proving, and it uses the word proving. In the instructions, I'm using the word determining instead of proving, and the reason for that is that at this time, I'm not explaining to the jury why I'm admitting the evidence. I'm explaining to them how they may consider the evidence that was admitted for that limited purpose, and of course, they can consider it only for that same limited purpose. But I think it's the only way to say it while avoiding confusing the jury. So I wanted to make a record of that. Is there any record that the people want to make with respect to that issue, Mr. Orman?
No, Your Honor, thank you.
All right, Ms. Nelson, without waiving your objections and that you have made with respect to that particular instruction and the requests that you have made, any record that you want to make with respect to that or any request that you want to make just with respect to that one issue that I just mentioned?
No, Your Honor.
All right, thank you. Do the parties have anything that I need to address before I bring the jury in, Mr. Brockler?
No, sir. I gave Ms. Brady an updated PowerPoint. My understanding is that she has no additional concerns or objections with it, but I'll let her say that. The other thing that I discussed with Ms. Brady was to respectfully request that the court, I understand we're going to take a break after the instructions, short break, before bringing the jury back in after the courtroom is filled with those who will be here. I wonder if in light of recent events the court wouldn't be willing to do another verbal admonishment of the gallery in light of the court's order.
I'm planning on doing that already. Thank you. Ms. Brady, anything from you?
No, sir.
Okay. What we'll do then is I'm going to bring the jury in. I'm going to read the instructions. I'm going to take a break at that point for about 20 minutes. Then we'll proceed with Mr. Brockler's closing argument. We'll then proceed after that with Ms. Brady's closing argument. And then I'll call you to the bench at that point and figure out if Mr. Brockler, if you have a rebuttal or if you want to think about it, and then based on that, I'll decide whether we should take a break or we can just proceed with my final instructions to the jury before sending the jury out to deliberate. Does that make sense? Yes. Okay, great. Thank you. Do either one of you wish to have any time warnings for purposes of your closing arguments? I know that I have given you 40 minutes. Mr. Brockler?
At 25 and 35 like we've done before.
Ms. Brady?
With 5 minutes left, please.
Okay, great. We'll
Thank
do
you.
that. Thank you. Thanks for reminding me. All right, let's bring the jury in, please. Joyce, do you have a copy of the instructions? We have one for you if you want. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Good afternoon, everyone. Please note that we're starting basically on time. It took till the last day of the trial, but I got it right finally. I figured out how to assess, make time assessments. The next step in the proceedings, as you know, is the jury instructions. And so I'm going to have my staff at this time distribute a copy of the Phase 3 sentencing hearing instructions at this time. Each of you is going to have a copy of the instructions. Feel free to mark or make notes on them. These are your copies, and you get to keep these copies. I have the original here, and you'll notice that it is stamped original. These will go back to the jury room where the deliberating jurors will be deliberating. We're also distributing a sample verdict form. It is marked sample. Each of you has a copy. And again, I have the original verdict forms here that we will send back to the deliberations room. All right, with that, does everyone have a copy of the instructions? No, we're missing, looks like we're missing some. Oh, we're not, it's just making its way. The second row is a little fuller than the other rows. Okay. All right, everyone ready now? Yes, okay. Jury instructions. Phase 3 of the sentencing hearing. Instruction numbers 1 through 23 given by the court this 6th day of August of 2015. Sentencing hearing Phase 3 instruction number 1. Members of the jury, Phase 3 of the sentencing hearing has now been completed. During the course of the trial and the sentencing hearing, you have received all of the evidence that you may properly consider in exercising your individual reasoned moral judgment to reach your final sentencing verdicts. I remind you that when I have made any references to the evidence and information presented in the courtroom during the proceedings, I simply meant the evidence presented in the courtroom during the proceedings. In a moment, I will read to you jury instructions that contain the rules of law that you must apply to reach your final sentencing verdicts. You will have copies of what I read to take with you to the jury room. But first, I want to mention some things that you need to keep in mind when you are discussing this case in the jury room. In these instructions, I refer to the first part of the proceedings as the trial and to the present part of the proceedings as the sentencing hearing, or more specifically, as Phase 3 of the sentencing hearing. If I refer to the proceedings, I am referring to the trial and Phases 1, 2, and 3 of the sentencing hearing. Until you have returned your final sentencing verdicts, you must follow all of the following admonishments. You must reach your final sentencing verdicts based only on the evidence presented during the trial, the evidence presented during the sentencing hearing, and the instructions provided by the court, which, among other things, inform you that in reaching each final sentencing verdict, you must exercise your individual reasoned moral judgment. However, to the extent that I tell you or have told you that you may only consider certain evidence for a limited purpose, you must only consider such evidence for the limited purpose that I tell you or have told you it may be considered. Do not communicate about the case with anyone else in any way, including in person, by telephone, cell phone, smartphone, iPhone, BlackBerry, computer, the internet, or any internet service. This means that you must not email, text, instant message, tweet, blog, or post information about this case or about your experience as a juror in this case on any website, listserv, chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, or Twitter. You must not communicate in any way with anyone else about this case or this kind of case. This includes your family members and friends. You must not read, review, or accept any communications in any form from anyone regarding this case or a case like this one. All you can tell family members, friends, acquaintances, and strangers is that you are a juror in Arapahoe County and that we anticipate that the proceedings will be completed by the end of August. If you notice that people are discussing the case, remove yourself from that location immediately. Do not attempt to gather any information on your own about this case or any case like it. You must not read or conduct any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or any other electronic means. Many of us routinely use the internet to research topics of interest, but you may not do that in relation to this case. You may not use Google, Bing, Yahoo, or any other type of internet search engine to learn about any person, place, or thing that is involved in this case. This includes the defendant, the attorneys, the witnesses, your fellow jurors, court personnel, and me. This applies whether you're here at home or anywhere else. Do not read about this case or any case like it in the newspapers or on the internet. Do not listen to any radio broadcasts about the case or any case like it, and do not watch any television news reports regarding the case or any case like it. You should do your utmost to avoid all news reports. Do not attempt to visit any places mentioned in this case. Do not in any other way learn about this case or this kind of case outside the courtroom. Do not talk to the witnesses, parties, and attorneys about anything. Do not talk to any members of the media about anything. Do not have any contact through any means, including in person, by telephone, text, or email with any jurors who have been discharged. You also should not have any contact through any means, including in person, by telephone, text, or email, with any of the alternate jurors. Make sure that you wear your juror badge whenever you're on the courthouse grounds and that your juror badge is visible to those around you. If you have a cell phone or other electronic device, you must temporarily surrender it to my staff. You're not allowed to have a cell phone or other electronic device in the jury room during your deliberations. You will get your electronic device at the end of the day before you go home. Lastly, although you may start deliberating when I tell you that you may do so, you may discuss this case only when you're all present and only when you're in the jury room. No juror should attempt to discuss this case with another juror or other jurors except when all the jurors are present in the jury room. All deliberations must occur in the jury room when all 12 jurors are present. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions that I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. At times during the proceedings, the attorneys have made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to the legal questions that I had to decide and should not influence your thinking. If I told you not to consider a particular statement during the proceedings, you must not consider it in your deliberations. Similarly, if during the proceedings I sustain an objection to a question after a witness had already provided an answer or partial answer, you must not consider any part of that answer in your deliberations. I may have asked questions of witnesses during the proceedings. That did not mean that I had any opinion about the facts in the case. Remarks and rulings that I have made during the proceedings should not be understood by you as suggesting any opinion or feeling on my part as to what has or has not been proven in this case. Likewise, remarks and rulings I have made during the proceedings should not be understood by you as suggesting any opinion or feeling on my part as to what final sentencing verdicts you should reach. Finally, the court's instructions of law are not intended as an expression of any opinion or desire concerning the final sentencing verdicts that you should reach. I remind you that I'm neutral in these proceedings. Sentencing hearing phase 3, instruction number 2. Each of you must fully appreciate your obligation to carefully and fairly consider the decisions that you have been called upon to make in this final phase of the sentencing hearing. These decisions may well be the most important and serious decisions that you will ever be asked to make. Sentencing hearing phase 3, instruction number 3. Your final sentencing verdicts are not dictated by law. Further, none of your earlier decisions in these proceedings dictates what your final sentencing verdicts should be. The outcome of your deliberations at the end of the trial, at the end of phase 1 of the sentencing hearing, and at the end of phase 2 of the sentencing hearing do not govern the ultimate determination that you must make now as to whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. In order to reach your final sentencing verdicts, each of you will be called upon to deliberate and to make decisions based on your individual, reasoned, moral judgment. Sentencing hearing phase 3, instruction number 4. You must now consider whether the defendant should be sentenced to life imprisonment without the possibility of parole or death on each count of murder in the first degree. This is a decision left exclusively to each of you. Each of you personally will determine whether the defendant will be sentenced to life imprisonment without the possibility of parole or death on each count. In reaching your final sentencing verdict on each count, each of you must exercise your individual reasoned moral judgment. The exercise of your individual reasoned moral judgment must be based on the evidence presented in the courtroom during these proceedings. Each juror's sentencing decision must reflect a profoundly reasoned moral response to the defendant's background, character, history, and crimes. With respect to each count, each of you must individually decide, based upon your reasoned moral judgment, whether or not you are convinced beyond a reasonable doubt that death is the appropriate sentence. No juror may ever decide that the defendant should be sentenced to death unless the juror is convinced beyond a reasonable doubt that death is the appropriate sentence. Further, the jury may only return a sentence of death on a count if every juror is convinced beyond a reasonable doubt that death is the appropriate sentence on that count. If one or more jurors are not convinced beyond a reasonable doubt that death is the appropriate sentence on a count, the defendant will be sentenced to life imprisonment without the possibility of parole on that count. A juror need not be convinced beyond a reasonable doubt that life imprisonment without the possibility of parole is the appropriate sentence in order to make a decision that will result in a sentence of life imprisonment without the possibility of parole. None of you individually, nor the jury collectively, is ever required to impose a sentence of death. The law never requires a death sentence. If any of you is not convinced beyond a reasonable doubt that death is the appropriate sentence on a particular count, that ends the inquiry with respect to that count, because in that situation the law requires that the defendant be sentenced to life imprisonment without the possibility of parole. Even if you're convinced beyond a reasonable doubt that the mitigating factors that exist do not outweigh the proven aggravating factors, you must still individually make a profoundly moral assessment or evaluation of the defendant's character and his crimes of murder in the first degree in order to determine whether or not you're convinced beyond a reasonable doubt that death is the appropriate sentence. Phase 3 is separate and distinct from Phase 2. Sentencing hearing Phase 3, instruction number 5. Based upon your verdicts at the end of the trial, the defendant has been found guilty of 24 counts of murder in the first degree. As you know, there are 2 guilty verdicts for murder in the first degree with respect to each deceased victim because the prosecution pursued 2 theories of liability as to each deceased victim: murder in the first degree after deliberation and murder in the first degree extreme indifference. The 2 guilty verdicts for each deceased victim will eventually merge into a single conviction for murder in the first degree, and based solely on the jury's final sentencing verdicts, the defendant will receive a single sentence for that conviction. Accordingly, the defendant will stand convicted of 12 murders in the first degree, and the jury's final sentencing verdicts alone will determine the sentences for those crimes. In Phase 1 of the sentencing hearing, you determined that the prosecution proved beyond a reasonable doubt 4 aggravating factors with respect to each count of murder in the first degree. In Phase 2 of the sentencing hearing, you determined that with respect to each count, the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution beyond a reasonable doubt. You must again make 24 separate determinations. This time, as to each of the 24 counts of murder in the first degree, you must decide whether or not, based on each juror's individual reasoned moral judgment, you are unanimously convinced beyond a reasonable doubt that death is the appropriate sentence. If you decide that a death sentence is the appropriate sentence on 1 or more counts, that sentence will be enforced regardless of the final sentencing verdicts on the remaining counts and regardless of the lack of a unanimous final sentencing verdict on any count. This is the case even if you impose different sentences on 2 counts that relate to the same victim, and even if you impose a death sentence on 1 count related to a victim and do not reach a unanimous final sentencing verdict on the other count related to that victim. Sentencing hearing Phase 3, instruction number 6. In Phase 3 of the sentencing hearing, there is no burden of proof. Therefore, neither party has the burden to prove anything to you. This rule applies regardless of whether a party chose to present evidence or not to present evidence in Phase 3. The defendant has presented evidence in these proceedings. You are instructed that the presentation of evidence by the defendant at any point in these proceedings does not place the burden on him to prove or disprove anything. A defendant never has any burden to convince the jury that the sentence of life imprisonment without the possibility of parole is the appropriate sentence, or that a death sentence is not the appropriate sentence. While neither party has a burden of proof in Phase 3, the degree of certainty that is defined as beyond a reasonable doubt nevertheless applies in this phase of the sentencing hearing. A juror may not determine that a death sentence is appropriate on any count unless he or she is convinced beyond a reasonable doubt that death is the appropriate sentence. Thus, in Phase 3, the use of the term beyond a reasonable doubt refers to the degree of moral certainty that an individual juror is required to have before he or she may decide, based on his or her individual reasoned moral judgment, that death is the appropriate sentence. An individual juror is not required to have the degree of certainty defined by beyond a reasonable doubt before he or she may decide, based on his or her individual reasoned moral judgment, that a life sentence without the possibility of parole is the appropriate sentence. Sentencing hearing, phase 3, instruction number 7. Reasonable doubt, as used in these instructions, means a doubt based upon reason and common sense, which arises from a fair and rational consideration of the evidence or the lack of evidence in the proceedings. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. Sentencing hearing, phase 3, instruction number 8. There's no requirement that you explain or justify to your fellow jurors why your individual reasoned moral judgment leads you to a particular decision on account. Nevertheless, it is your duty as jurors to consult with one another and to deliberate on all the counts. While you are not required to agree with the determinations, opinions, feelings, or thoughts of other jurors, you must deliberate with your fellow jurors. After deliberating, if a juror disagrees with the rest of the jurors, that disagreement must be respected by the other jurors and will be respected by the court. Ultimately, each of you must deliberate and decide for yourself the appropriate sentence based on your individual reasoned moral judgment. Sentencing hearing, phase 3, instruction number 9. In reaching your final sentencing verdicts, you may consider mercy and sympathy for the defendant. Your exercise of mercy and sympathy must be based upon the evidence presented during the proceedings. Sentencing hearing, phase 3, instruction number 10. Under Colorado law, when a person is sentenced to life imprisonment without the possibility of parole, it means that the person must spend the rest of his natural life in prison. A person who has been sentenced to life in prison without the possibility of parole cannot ever apply for parole or cannot ever be paroled. Sentencing hearing, phase 3, instruction number 11. Under Colorado law, the manner of enforcing a sentence of death is by the administration of a lethal injection. You must assume that a death sentence will be carried out if the jury determines beyond a reasonable doubt that it is the appropriate sentence. Sentencing hearing, phase 3, instruction number 12. You are instructed that the fact that the prosecution seeks the death penalty in this case is entitled to no weight whatsoever in your decisions. No juror should allow himself or herself to be influenced or prejudiced against the defendant because of the fact that the prosecution seeks the death penalty. Sentencing hearing, phase 3, instruction number 13. In reaching your final sentencing verdicts, you must treat the defendant as a uniquely individual human being. Further, you must not be influenced by prejudice or bias of any sort against the defendant or the prosecution, and you must not consider any public opinion or community sentiment for or against the defendant or the prosecution. Your decisions may not be the result of any irrational or arbitrary emotional response. Rather, each of your final sentencing verdicts must reflect your individual reasoned moral determination. Sentencing hearing, phase 3, instruction number 14. In phase 3, you received victim impact evidence, which is evidence of any matters relating to the personal characteristics of the deceased victims and the impact of the crimes of murder in the first degree on each victim's family. The purpose of such evidence is to inform you about the harm caused by the crimes of murder in the first degree. You may consider this evidence in reaching your final sentencing verdicts. However, your consideration must be limited to a moral inquiry into the culpability of the defendant, not an emotional response to the evidence presented. You are never permitted to make a comparative judgment between the defendant and the victims. Sentencing hearing, phase 3, instruction number 15. The court reminds you that the number of witnesses testifying for or against a certain fact during the proceedings does not by itself prove or disprove that fact. Sentencing hearing, phase 3, instruction number 16. The court reminds you that you're the sole judges of the credibility of each witness who testified in these proceedings and the weight to be given to each witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. Sentencing hearing, phase 3, instruction number 17. The court reminds you that you're not bound by the testimony of witnesses who testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony is entirely your decision. Sentencing hearing, phase 3, instruction number 18. In reaching your final sentencing verdicts, you may consider all of the evidence admitted during the proceedings. Dr. Jeffrey Metzner's testimony during phase 2 of the sentencing hearing, which was admitted for the limited purpose of determining the existence or absence of any mitigating factor, may only be considered for that limited purpose. Additionally, the evidence admitted during the trial for the limited purpose of considering the issues raised by the defendant's plea of not guilty by reason of insanity may only be considered for the limited purpose of determining the existence or absence of any mitigating factor. Finally, any other evidence that the court instructed you throughout the proceedings could only be considered for a limited purpose may only be considered for that limited purpose. Sentencing hearing, phase 3, instruction number 19. Every person charged with a crime or convicted of murder in the first degree has the constitutional right not to testify. The defendant did not testify during the trial or during the sentencing hearing, as was his right. You should not draw any negative inferences from his choice as to the punishment to be imposed or any other matter. You shall not allow his choice to prejudice him in any way. His decision not to testify cannot be used as a reason to support or impose the death penalty. You must not discuss the defendant's choice not to testify or permit it to enter into your deliberations in any way. Sentencing hearing, phase 3, instruction number 20. You were permitted to submit written questions to witnesses throughout the proceedings. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror was not a reflection on the person asking it, and you should not attach any significance to the failure to ask a question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express any opinion about the question. My decision whether or not to allow a question was based on the applicable rules of evidence and other rules of law, and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and the rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that were submitted by yourself or your fellow jurors. Sentencing hearing, phase 3, instruction number 21. You've been allowed to take notes. Whether or not you took notes, you should rely on your memory as much as possible. The notes that you took are to refresh your own memory. You should not give additional weight to the comments of any juror based upon the quantity or quality of his or her note-taking. Sentencing hearing, phase 3, instruction number 22. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to one of my bailiffs who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and final sentencing verdict forms. Sentencing hearing, phase 3, instruction number 23. Following the attorney's closing arguments, the bailiffs will escort you to the jury room so that you may deliberate. Your foreperson will preside over your deliberations. You will be given 24 separate final sentencing verdict forms, one for each count of murder in the first degree. Each verdict form has 3 sections, 1, 2, and 3. Your final sentencing verdict on each count must be reflected in Section 1, Section 2, or Section 3 of the verdict form. As to each of the 24 counts of murder in the first degree, you must decide whether or not, based on each juror's individual reasoned moral judgment, you are unanimously convinced beyond a reasonable doubt that death is the appropriate sentence. If the jury is unanimously convinced beyond a reasonable doubt that a death sentence is the appropriate sentence on a count, the foreperson and the other 11 jurors should sign on the designated lines in Section 1 of the final sentencing verdict form for that count. In that event, the defendant will receive a death sentence on that count, and that sentence will be carried out regardless of the final sentencing verdicts on the remaining counts and regardless of the lack of a unanimous final sentencing verdict on any count. If the jury is not unanimously convinced beyond a reasonable doubt that a death sentence is the appropriate sentence on a count, and the jury unanimously agrees that the defendant should be sentenced to life imprisonment without the possibility of parole on that count, the foreperson should sign on the designated line in Section 2 of the verdict form for that count. In that event, the defendant will receive a sentence of life imprisonment without the possibility of parole on that count. If the jury does not reach a unanimous final sentencing verdict on a count, because it is neither unanimously convinced beyond a reasonable doubt that death is the appropriate sentence, nor in unanimous agreement that the defendant should be sentenced to life imprisonment without the possibility of parole, the foreperson should sign on the designated line in Section 3 of this verdict form to indicate that the jury does not have a unanimous final sentencing verdict on that count. In that event, the court will be required by law to sentence the defendant to life imprisonment without the possibility of parole on that count. Only one section, Section 1, Section 2, or Section 3, shall be completed on each verdict form. The final sentencing verdict forms and these instructions shall remain in the possession of your foreperson until I call for them in open court. Upon reaching your final sentencing verdicts, you will inform the bailiff that you have completed all of the final sentencing verdict forms, and the bailiffs in turn will notify me. You will then remain in your jury room until called into the courtroom. In your communication, please do not indicate whether you have reached a unanimous verdict on any count or counts. Simply indicate that you have completed all of the final sentencing verdict forms. I will now read a sample final sentencing verdict form. You must not draw any inferences based on the verdict form I have selected to read to you. Does everyone have the sample verdict form, a copy of it that was distributed? And everyone's saying yes, nodding their head yes. Final sentencing verdict form, count 1, murder in the first degree after deliberation, Jonathan Blanc. Roman numeral 1, single asterisk. We, the jury, are unanimously convinced beyond a reasonable doubt that the appropriate sentence for the defendant, James Egan Holmes, on this count is a death sentence. And then there are 12 spaces there for the juror's signature, including for the foreperson, in case that is the jury's sentencing verdict. Roman numeral number 2, double asterisk. We, the jury, are not unanimously convinced beyond a reasonable doubt that the appropriate sentence for the defendant, James Egan Holmes, on this count is a death sentence, and we, the jury, unanimously agree that the defendant should be sentenced to life imprisonment without the possibility of parole on this count. And then there's a space there for the four-person signature in case that is the jury's sentencing verdict on this count. Roman numeral 3, triple asterisk, we, the jury, do not have a unanimous final sentencing verdict on this count, and we, the jury, understand that as a result, the court will impose a sentence of life imprisonment without the possibility of parole on this count. And then there is a space there for the four-person signature in case this reflects the outcome of your deliberations. Second page, single asterisk, which applies to section 1. If the jury is unanimously convinced beyond a reasonable doubt that a death sentence is the appropriate sentence on this count, the foreperson and the other 11 jurors should sign on the designated lines in section 1 of this verdict form. Sections 2 and 3 should then remain unmarked. Only one section may be completed on this verdict form, section 1, section 2, or section 3. In the event that the jury completes section 1 of this verdict form, the defendant will receive a death sentence on this count, and that sentence will be carried out regardless of the final sentencing verdicts on the remaining counts and regardless of the lack of a unanimous final sentencing verdict on any count. Double asterisk, which applies to section 2. If the jury is not unanimously convinced beyond a reasonable doubt that a death sentence is the appropriate sentence on this count, and the jury unanimously agrees that the defendant should be sentenced to life imprisonment without the possibility of parole on this count, the foreperson should sign on the designated line in section 2 of this verdict form. Sections 1 and 3 should then remain unmarked. Only one section may be completed on this verdict form, section 1, section 2, or section 3. In the event that the jury completes section 2 of this verdict form, the defendant will receive a sentence of life imprisonment without the possibility of parole on this count. Triple asterisk, which applies to section 3. If the jury does not reach a unanimous final sentencing verdict on this count because it is neither unanimously convinced beyond a reasonable doubt that death is the appropriate sentence, nor in unanimous agreement that the defendant should be sentenced to life imprisonment without the possibility of parole, the foreperson should sign on the designated line in section 3 of this verdict form to indicate that the jury does not have a unanimous final sentencing verdict on this count. Sections 1 and 2 should then remain unmarked. Only one section may be completed on this verdict form, section 1, section 2, or section 3. In the event that the jury completes section 3 of this verdict form, the court will be required by law to sentence the defendant to life imprisonment without the possibility of parole on this count. All right, folks, that concludes the reading of the instructions and the sample verdict form. What we're going to do now is take a break for 20 minutes, and then we'll proceed with the closing arguments. As I indicated, I have given each side 40 minutes. The prosecution goes first, and then if there is a rebuttal argument, I have given each side 20 minutes, again with the prosecution going first and the defense going last. Please make sure that you keep in mind all my advisements during the break. You're not allowed to talk to each other about the case or any of the proceedings, and you should leave the instructions and the sample verdict form on your chair. Do not take them with you during the break, okay? All right. I'll see you in 20 minutes. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Is there anything that we need to discuss at this time on behalf of the people, Mr. Brockler?
No, Your Honor, thank you.
Anything on behalf of the defense, Ms. Brady? All right, let's take our 20-minute break, and I'll see you back here after the break. Thank you. The court will be in recess.
All rise.